Good morning, everyone.
In unison, good morning, Your Honor.
Where's the witness? You may be seated. You're still under oath.
Okay.
Go ahead.
Thank you, Your Honor.
Good morning, Mr. Sneddon.
Good morning, Mr. Nimmer. How are you this morning?
Good, thank you.
I just have a few more questions.
Okay, sure.
I want to go back to what we talked about yesterday just to try to get a point of clarification. Between yesterday and this morning, did you get a chance to review the video again?
No, I didn't.
Okay. Do you recall yesterday we were talking about how, in scene 2, the chimes went off and was very faint at one point and then louder at another point in the scene?
Yes.
And do you recall me asking you yesterday? I believe. And if I'm not saying this correctly, you correct me. I believe your explanation was you thought one was when they went out the door and the other was when they came back in?
Yes, that was my guess.
And then I asked you yesterday, in the scene 1, when the maid goes out the door, whether the chimes went off or not. Do you recall that?
I believe so.
And you said you believed the chimes did go off?
That's correct.
When this video was made, was Joe Marcus present?
Yes, he was.
Was a defense investigator by the name of Scott Ross present?
No.
Or Mr. Castillo?
No.
So the representative there was Mr. Marcus?
And one other person from Neverland Ranch was a woman whose first name was Grace.
Okay. And where was Mr. Marcus during the time that you were doing the filming?
Standing behind me.
So he was in your presence the entire time?
Correct.
Okay. Now, one of the other questions I'm going to ask you and then I'm going to show you the video again, just a part of it.
Sure.
In the first scene, when you're downstairs and you ask the maid, Maria Gomez, to walk out, and then you hear the chimes go off, okay?
Yes.
When you're standing there, where are you standing? Next to the throne chair?
No, I'm standing kind of right in the middle of the room, more or less. Probably 10 or 15 feet from the doorway into the center of the room. And when you say, the throne chair, do you mean the large chair that leads into the next room where the stairway is to the upstairs bedroom?
Yes, sir.
Yeah, so it wasn't that far away from me. The room is not that large, but I was about in the center of the room.
Okay. And when you filmed the scene 1 material, scene 1, could you tell where the sound was coming from? From your right or from your left?
I couldn't say.
Okay. I want to, if we could have. I think it's already on the right one, Your Honor.
All right.
If we could just have the lights for just a second. And we're going to play Exhibit 5096 in just the scene 1.
Go ahead. Whereupon, a portion of a DVD, Defendant's Exhibit 5096, was played for the court and jury.
Okay, let's stop it right there. Now, would it be a fair statement to say that that chime did not go off when she went out the door, did it?
Possibly it was triggered from her going out the door and didn't ring immediately. But frankly, I don't know one way or the other if it was triggered by her going out or coming in.
Do you know where the sensor is that's closest to the door?
No, I don't.
Objection. Asked and answered.
Overruled. It's answered. Next question.
In the segment on scene 2 where there is a faint sound and then a louder sound. Okay. There is probably a 5 or 10 second delay between the two sounds, correct?
Correct.
And that's what led you to believe that the first sound was when she exited the door and the second sound was when she came back in, correct?
That's correct.
And that did not occur on scene 1, did it?
Well, you didn't let it continue playing. Is there another set of rings after that one?
I don't think so. But we can play it. Go ahead.
Do you want to play it again?
Yes, sir. Let's start over. Yeah, let's go back again.
You may need to hit stop twice to reset it to the top. Whereupon, a portion of a DVD, Defendant's Exhibit 5096, was played for the court and jury. That's the second set.
Okay, right. And they were almost back to back, were they not?
Correct. And on this take, I asked her to go out and come back in, which she did. When I was upstairs, I asked her to wait about 10 seconds after she went out before she came back in, so that it was more clear when she's coming in and when she's going out.
Alright, So your explanation is that in scene 1, you didn't give her the instruction. A similar instruction to the one you gave her in scene 2 and scene 3?
That's correct.
Alright. The individual you identified as Grace, where was Grace during the filming?
Standing behind me as well.
Alright. Let's move on to the second video.
Okay, sure.
I just have a few questions on that. I believe you said you went out there on multiple occasions?
That's correct.
About 4 or 5.
Correct.
And on those occasions that you went out there, the folks knew you were coming. I'm assuming you made previous arrangements?
Right.
And prior to going out there, you told us before that you had been advised by somebody to make sure you take pictures of the clocks, correct?
Correct.
Was that somebody connected with the defense?
Yes.
Were there any other things that they told you that you should focus on in that film?
Well, let's see. Basically all of what I saw while I was out there. I was asked to get shots of the guest house, the guest rooms. I was asked to get some shots of some of the paintings by the artist Nordahl, and, as well as various other places, including the arcade, the amusement park, the zoo, etc.
Okay. Now, when I was looking at the film, it appeared to me, and you would be the best person who would know this, that some of the library shots about the books on the shelves were taken in a small library located on the top floor of the arcade. Is that correct?
That's correct.
Okay. Now, part of this video was to show. The objective view of it was to show a day in the life of somebody who may be visiting the ranch, correct?
Correct.
Did you have an understanding that that was a room up there that was open to the public?
I didn't really know one way or the other. Anything that's personal of Mr. Jackson's I think would be of interest to the public, so it was interesting to see what his books, a cross-section of his books are.
But you didn't know when you went up there whether or not that room is actually locked most of the time or not.
I don't know one way or the other.
And whether the public was invited to use that room?
I don't know one way or the other.
Now, just a couple of more questions. Let me ask you this. Were you asked to film the employee break room?
Not that I recall.
Were you asked to film the cellar?
No.
Were you asked to film Mr. Jackson's office?
Yes, I was, actually.
Did you do that?
No.
Were you asked to film the bathroom area in the bathroom that's adjacent to the arcade?
No.
Were you asked to film? I guess I asked you that. And you did film the kitchen, correct?
Correct.
Were you asked to film the location of the refrigerator in the kitchen?
No.
And you say that you were attempting to portray this as an objective view of what somebody would see at the ranch. But in reality, some of the decisions that were made were subjective on your part, correct?
Correct.
Objection. Argumentative.
Overruled.
Nothing further, Your Honor.
Mr. Sanger?
All right, Mr. Nimmer, first of all, why were Grace and Joe Marcus there?
Frankly, I'm not sure why. Perhaps so that they could make sure I didn't tamper with anything in the room. They led me to where the different rooms are. They know their way around better than I do.
So when you made arrangements to go to the ranch, did somebody accompany you so you could go in the different locations?
Yes, at most all times somebody always accompanied me.
Did anybody prevent you from taking pictures of anything in particular?
No.
All right, now, with regard to the last questions about the tape of Neverland itself, you were asked about filming certain areas like the cellar and the break room and all that. Were there other interior areas of buildings on that ranch that you did not film?
Yes.
And was this an effort to film every part of every building on that ranch?
No.
If you were to do that, even in the abbreviated format you have here, how long would your video end up being?
Well, possibly hours. Much longer.
Okay, let's talk about the doorbell test. Were you asked to do any technical evaluation of the alarm system?
No.
Is that within your particular expertise?
That isn't my expertise.
Do you have reason to believe that there are other people who have such expertise?
Yes, I do.
All right. Secondly, with regard to the decibel level that was asked about last time, did you have any decibel level, any known decibel level, to compare decibel levels to had you determined the decibel level? Do you know what I'm saying?
I did not.
So if you do a decibel level test, you generally need to have something else, some other known level to compare it to, right?
Correct.
Alright, were you asked to do decibel levels at all?
No, I was not.
What were you asked to do with regard to the doorbell test?
To do a video and audio recording in those two environments to get a general sound of what it sounded like with the alarm going off.
And were you asked also to listen to it while you were doing it?
Yes.
And did you compare what you heard to what was seen on the tape?
Yes, I did.
What was heard on the tape, more accurately?
Correct. What was heard?
Okay, thank you very much.
Thank you.
Mr. Nimmer, you were trying to produce something that would be useful to the jury in reproducing the sound created by those chimes, correct?
Correct.
And to that extent, wouldn't the first thing that you would want to do is to ask Mr. Marcus or Grace whether or not the sound system that was in there was the same, the chime system that was in there was the same one that was in there back at the time of these events?
I did ask them if the room was set as close as possible to how it was back in 2003, and they said it was.
Okay, but you didn't ask them about the actual chime system itself, did you?
I didn't ask about anything specifically.
And you were talking about, I think you told us yesterday you were talking about the furniture, were you not?
I was talking about everything in general.
In specific with regard to the chime system, which was why you were really there, you never asked them that question, did you?
Objection. Argumentative. Compound.
Asked and answered. Sustained.
With regard to the integrity of the product that the jury has just seen, you would agree with me, would you not, if there was differences with the way the actual chime system was hooked up, or the equipment that was there, if it was different from February or March of 1990, of 2003, that it would not be an accurate reproduction of what you displayed to the jury, would it?
Objection. Asked and answered. Beyond the scope. Sorry. Asked and answered and beyond the scope of redirect.
It's argumentative. Sustained.
Had you asked the specific question of whether the system that you reproduced on this video was the same as the one that was there, let's say, on November 18 of 2003, then we would know for certain that what you reproduced was the same, correct?
Argumentative. I thought the question was over. I apologize.
It was.
Okay, I object. Argumentative.
Sustained.
I have no further questions.
No further questions, Your Honor.
All right, thank you. You may step down.
Thank you, Your Honor.
To the jury, all right. We only have one other witness, and before we can have him come in, I have to make some rulings. So I'm going to ask you to step out, and we'll do this as quickly as we can. You may be seated. Do you want the witness in for this?
Yes.
Come forward to the witness stand. You may be seated.
Thank you.
You're still under oath.
Thank you.
All right, I've received the points and authorities that I requested. Thank you, everybody, and reviewed them. I've also received a revised or amended waiver of attorney-client privilege work product that changes the written date, or the date of the written waiver to commence in November as opposed to December, which the original one stated, so I accept the new date for purposes of our discussions. I don't think it's an issue that I'm going to. I accept that there was just a mistake on the dates, so that's not an issue. I have a sense of what I want to do, but before I do that, Mr. Sneddon, does your side wish to add anything or make any further arguments?
Your Honor, I think the defense would be the moving party, I believe, to the extent that they're asking that the court observe a conditional waiver at this point. Perhaps I'll respond to what they have to say rather than give a statement at this time.
All right, is there anything that you wish to add? Are you speaking?
Yes, I am, with the court's permission. Even though this is Mr. Mesereau's witness, I started arguing the motions, and I'll finish, if that's all right with the court in this one instance. There's nothing else that we didn't say, but there is at least a sentence or two in here that might bear a little amplification. As I think is pretty clear, our position should be that there is a limited waiver, that satisfies all the requirements of this proceeding. And the sentence, I think, needs a little amplification. The sentence or two is that if the door were opened, since we talked about opening doors. If the door were opened and there was a general waiver, it would lead to irrelevant material. It would lead to material that's not going to come into this case anyway. But it would also be quite a disaster, I think, from the standpoint of the attorney-client privilege for Mr. Jackson, beyond the point of the adversarial proceedings starting, which would include communications that Mr. Geragos had with co-counsel and investigators and even counsel, perhaps, after he was no longer involved in the, or he's no longer attorney of record in the case. And based on that, I think, that alone, I think, is the kind of prejudice that the court would want to avoid. And so I'd ask the court to just consider that in the context of the rest of what we filed, including the need for a knowing and intelligent waiver on the part of the defendant himself and the relevance issues. Thank you.
Your Honor, here's our concern. When we began direct examination of Mr. Geragos, we were under the understanding, given the waiver that was executed in open court in the defendant's presence by Mr. Mesereau, that this was an unconditional, unqualified waiver as to all aspects of the attorney-client relationship. All of direct examination was concluded, and cross-examination commenced until we discovered that, after a break, there had been a qualified waiver executed in writing. There were 3 attorneys in the room who knew that happened. Mr. Geragos knew it because he had been furnished a copy of it. Mr. Mesereau knew it because the signature on it by Miss Yu indicated that he had reviewed the document for content and approved it. And Miss Yu knew it because she drafted the document. None of the 3 attorneys, when they came into court, either furnished the court a copy of that waiver or furnished the prosecution a copy of that waiver. And none of those 3 lawyers told either the court or the prosecution that the waiver had changed, unilaterally had changed from an unconditional, unqualified waiver to a very conditional, qualified waiver that would end at the time of the defendant's arrest. Now, we went through all of direct examination and a good portion of cross-examination with an understanding, at least from our standpoint, and I believe from the court's standpoint, that it was an unqualified, unconditional waiver, and that's how we were going to conduct cross-examination. As the court pointed out, you can't give and then take away at the same time without telling us. And I believe the fact that we weren't told, either the court or the prosecution, during the course of that break, neither one of us were furnished copies of the waiver and instructed that the terms and conditions of the waiver had taken place. And I believe that we should proceed with cross-examination as if it were an unconditional, unqualified waiver, and proceed with appropriate objections for relevancy and appropriate objections for any other evidentiary issues, but that the waiver should be unqualified.
Just a factual issue, Your Honor. I don't want to re-argue what we've already argued in writing. But on a factual issue, I believe that Miss Yu did give your clerk a copy of the waiver before the break. During the break at the same time it was given to Mr. Geragos, and I believe that a copy was given to the district attorney at the same time.
No, it wasn't.
Yes, it was. Yes, it was.
Wait. That's okay.
I'm reporting. I did personally see Miss Yu go up to Miss Frey, your clerk, to give a copy. So
It's really insignificant, whether you revealed this at the break or 10 minutes after the break. I mean, the fact is that there was a complete change in what the purported waiver was.
There.
You can sit down. That's okay.
All right, thank you, Your Honor.
I did review the entire testimony of Mr. Geragos last night before considering my rulings in this matter, and there are 2 issues that we're dealing with. One is questions beyond the scope of the direct examination and the other is the scope of the attorney-client privilege waiver. And we do have Mr. Geragos's assertion that I assume hasn't changed. But you will claim the privilege based on the waiver. Is that, regardless of my ruling?
Regardless of your ruling, I'm going to claim the privilege. I've been furnished, as I don't know if it was furnished to the court. I think you said it was.
It was, yeah.
The other, and regardless of the ruling, I'm still going.
You will make.
I will stand on that.
Make that claim?
Yes.
That was my understanding from what you said last week, but I think I should. Thank you for affirming that. That puts us in a difficult situation. There's things that I could do, and that would be to strike his testimony. In looking at the examination, I'm not sure who that would punish in the end. I mean, there was some direct examination, there was more lengthy cross-examination. Nobody's moved that I strike his testimony, and if you do, the jury has heard it. We strike things all the time, but we all know you can't, we don't really know what the effect of trying to unring a bell is. You give people instructions not to consider things, but hope that they're capable of doing that. But it doesn't appear to be a really good remedy at this time, although I could consider it. I feel deceived by Mr. Mesereau, and I am considering, although I've reached no conclusion at this point, and I don't want to divert the process of the trial with this type of thing, but I'm considering sanctions of some sort against Mr. Mesereau. Again, that doesn't really help or hurt in the factual presentation. So at this point I think what I'm going to do is to recognize, according to the law, that there is a qualified privilege and accept the waiver as it stands only up until November 2003. But I am going to, and then I'm going to allow the prosecution to continue their examination, and I'm going to require that any claim of privilege between attorney-client be made in front of the jury so that the jury understands what is actually happening in the courtroom. You know, we've had several other situations. Some, I've said, privileges had to be claimed in front of the jury. Some I've said they are not to be claimed in front of the jury. And it's a factual situation. You know, you get to that conclusion based on all of the surrounding facts. And in this case, I think it would be productive for the jury to know that the privilege is being claimed. Mr. Geragos before, which is really the proper thing, kind of what I wanted him to do, was not, you just said, I can't answer that, which clued me in it was a claim of privilege, but nobody else really. So that will change now. You'll have to say, I'm claiming the attorney-client privilege and cannot answer that question.
I did not assert that before because I didn't have the court's ruling or guidance.
I'm saying that you did the right. You did it the way I wanted you to then, but now we're changing the rules.
That's fine.
Okay, so that's my ruling on the issue. And you can bring the jury back in.
Before you do that, just one further point of clarification, if I could.
Yes.
I know this is Mr. Mesereau's witness, but this will be my last remark with regard to the motion.
I think it's.
Would the court still entertain objections that it's beyond the scope and relevance with regard?
Yes. I said there's two issues.
Yes, sir.
I haven't abrogated the rule that you called this witness for a specific purpose. And in reviewing the rulings that I made last week, which it's a luxury, you know, to be able to go back and review, I think I was making the correct rulings because of his assertion. So where you thought that the district attorney was exceeding the scope and I ruled that he was not, I still feel that way. You know, he's made some assertions about what he knew at the time that he was advising, and that area I had allowed them to open up, so I would continue to allow that area to be opened up. But there's, of course, there's the, I don't want to say too much, but that, I think, addresses something that should have been addressed.
I appreciate that. Thank you, Your Honor.
Do you have any questions, Mr. Zonen?
Your Honor, we did, in fact, request of the court that the court consider the option of striking the testimony of this witness in its entirety. I'm not going to renew that at this time. But I'd like to see what happens in terms of cross-examination at this point vis-a-vis his assertion of that privilege. And I wouldn't bring that up in front of the jury.
A better way for me to have said what I was trying to say was that I won't grant a motion to strike at this time, but I would reconsider one at some other time if.
And that's what I was asking.
If it's made, and I'm not inviting it. I'm just saying at this time, when I weighed the testimony that had been given, I didn't think that was the way to go.
That's fine.
All right, let me.
Oh, before. A different matter, just real quick, Your Honor.
Yeah.
You still have the amen testimony issue.
Yes.
Amen. Joining in the bailiff spirit of coming together here.
They can't hear you.
Okay, we're hoping to have a ruling on that in time that we could, if we're able to call him, we would be able to get that in motion, so.
I'm prepared to make a ruling on that. My suggestion is we have the jury in. We finish this, and then we deal with that when we can let them go, instead of taking more time now.
Perfect. Thank you.
I'm just going to step off the bench so that you can bring the jury in. I'll be right there, ready to come right back. Okay. You may proceed.
Thank you, Your Honor. Mr. Geragos, good morning.
Good morning, Mr. Zonen.
Mr. Geragos, you were aware in advance of the meeting with the Department of Social Services, Child and Family Services, that there was going to be a meeting involving Janet Arvizos. Is that correct?
Yes.
Who was it who notified you or advised you of that fact?
Probably would have been Brad.
Did you know at the time that there was going to be somebody working for Brad Miller who would be attending that meeting?
I don't think so.
Did you instruct Brad Miller to be there?
No.
Did you have a conversation with Brad Miller before that meeting?
I think that would have been the conversation where he told me about the meeting.
Alright. Did you express concern to Brad Miller about comments that Janet Arvizos might make to the workers, social workers?
I don't think so. I don't think I expressed concern about comments she might make. I think as I testified to last week, I think the question was she wants somebody, or wants to talk to a lawyer or something to that effect, and that's when I gave Mr. Nassatir's name.
Alright. Now, you did not know at the time that there was going to be a representative of Mr. Miller who would be there.
Like I say, as I sit here today, I don't think that I knew that either he or Asaf were going to be there. I don't know when I learned that.
And Mr. Miller never consulted with you in advance about the propriety of tape recording that conversation?
I had no idea up until the time that the search warrant was issued or executed that there was any kind of a tape that was done.
Were you aware as of that day of Brad Miller ever having tape recorded illegally conversations prior to that time?
Well, I don't know that was. If you're suggesting that was an illegal taping, I don't believe that was an illegal taping. And the previous taping that I was aware of, he told her, Janet Arvizos, that he was working for me, that he had a tape recorder, and that he was taping it, and something to the effect, if memory serves, that okay?
Mr. Geragos, do you believe that it's legal to surreptitiously tape a Department of Child and Family Services interview?
I don't believe that you can surreptitiously tape their interview, no. I don't think that would be legal.
Is it your opinion, as an attorney specializing in criminal law, that the interviews with the Department of Child and Family Services are confidential?
Yes.
And therefore, somebody tape recording it for purposes of being able to listen to that conversation, that would be in violation of the confidentiality laws. Is that true?
I don't know if it would be in violation of the confidentiality laws. I think it would probably be a violation of a penal code section.
In any event, it would be illegal?
In my opinion, it probably would be.
You are not aware of Mr. Miller ever having done that in the past, is that correct?
Well, I'm aware.
Objection. Relevance.
Overruled. You may answer.
I'm aware of many private investigators, and I would probably say Brad included, who understand that the penal code has exceptions. And one of the exceptions is if you believe that there are certain enumerated crimes that are going to be committed, you are allowed to, under the code section, tape surreptitiously. So I don't know. Your definition of whether or not it's illegal or not and mine probably differ, but I think that the penal code clearly states that there are exceptions when you can tape.
Did you believe that there was going to be a crime committed at the Department of Child and Family Services interview with Janet Arvizos?
As I told you, I don't know what was going to happen there. But I think what you're asking me is in reference to the other tape that was made.
No, sir, I'm asking.
Which was with Mr.
About the Department of Child and Family Services interview. Did you believe there was going to be a crime committed during that interview?
No, I didn't believe that a crime was going to be committed because I don't think that I had a discussion as to what was going to take place, other than to say, look, I can't represent her. Talk to Nassatir.
And you did not tell Brad Miller that you thought there would be some kind of crime committed during the course of the Department of Child and Family Services interview?
Well, if she would lie to them, that would be potentially a crime, I suppose. But I don't know if I had.
And did you tell Brad Miller that?
I don't know that I had that discussion with Brad. In retrospect, who knows what she was going to say?
And Brad Miller did not tell you that he planned on tape recording that interview?
Did not.
And if he had, you would have told him not to?
Well, if he had told.
Objection. Calls for speculation.
Sustained.
When did you first get possession of that tape?
After
Objection. Relevance. Beyond the scope.
Overruled.
And I'd have to, Your Honor, as the court instructed, I'd have to assert attorney-client privilege at this point.
You refuse to answer based on the attorney-client privilege?
Could I?
Is that right?
Yes.
Next question.
From whom did you first learn that that conversation had, in fact, been tape recorded?
I believe, as I sit here today, the only conversation that was tape recorded was something between Asaf and Janet Arvizos. I don't know. As I sit here today, I haven't listened to that tape in quite a while. I don't know how lengthy that tape was. I thought it was just between Janet and Asaf.
From whom did you first learn that there had been a tape recording that took place at Jay Jackson's apartment while the Department of Child and Family Services workers were there?
Objection. Beyond the scope. Relevance. Assumes facts.
Overruled. You may answer. Do you want the question read back?
No, I remember the question. I'm just trying to. I couldn't tell you if I learned it from. It was either from Brad or when I got copies of the documents that were seized, when I had asked Mr. Sneddon for that. So I might have gotten the items from Mr. Sneddon, and he had represented to me that he had not listened to them yet, so.
And Brad Miller, did he brief you on the content of the interview with the Department of Child and Family Services interview?
At what point?
After it occurred.
Objection. Beyond the scope. Relevance.
Sustained.
When was the first time you had a conversation with Brad Miller following the Department of Child and Family Services interview?
Objection. Relevance. Beyond the scope.
Overruled.
I couldn't tell you as I sit here. I'm sure it was sometime shortly thereafter, but I just don't know.
Did you ask him about how he knew about the content of that interview?
I'm sure he would have. Well, I would just be speculating.
Did he tell you that he had somebody there at the time?
No, it was. I can't. If you're asking me for, in February, what I knew then, I would only be speculating. I think what he told me was that he had Asaf there because Janet wanted somebody there, and then Asaf left, is I think what I was told in February.
Alright. Between the time of this interview with the Department of Child and Family Services and the time your client was arrested in November, did Brad Miller ever tell you that that conversation was tape recorded?
Objection. Relevance. Beyond the scope.
Sustained.
Did you receive a copy of the tape recording at any time between the interview on the 20th of February, 03, and the time that your client was arrested in November?
Objection. Relevance. Beyond the scope.
Sustained.
I'm sorry?
Sustained. I think the relevant period is through April. That's why I'm sustaining the objections.
Okay. If I were to ask those questions again through the end of April, would your answer be different? Let me change that question. Between the time of the interview on the 20th of February through the end of April, did you receive a copy of the tape of that interview?
I don't know. I couldn't tell you.
You might have?
I don't think so, but I couldn't tell you. I don't think that I did. I don't think that I was aware of that or the other tape until after the search warrant, but I'd just be guessing.
Now, you commenced surveillance of the Arvizos family, is that right?
Not me personally, but I asked Brad to find out who they were meeting with, what they were doing. So if he surveilled in response to that, that would be what I would have expected.
You didn't personally want to sit in a car in East LA and watch them?
Objection. Argumentative.
Sustained.
Did you have a conversation with Mr. Miller as to who was going to participate in the surveillance?
No.
Did you give Mr. Miller any direction as to what they were supposed to do?
I think the same thing I testified to before. Find out where they are, who they're meeting with, and what they're doing.
Did you tell them to surveil the children?
Well, I assumed that the children would be in the company of adults, and that one of the adults would be Janet Arvizos.
Did you?
That would be the assumption.
Did you tell them to conduct surveillance of the children when they're not in the presence of the adults?
I don't think we had that discussion, no.
Did you tell Brad Miller to have people conducting surveillance of the children while they were coming and going from their junior high school?
No, I didn't give him specific instructions as to what to do. I think I just gave a broad directive that said, I want to know who they're meeting with, what they're doing.
Did you tell Brad Miller that the surveillance operatives should be obvious so that the children know they're being followed and taped?
Objection. Argumentative. Assumes facts.
Overruled. You may answer.
No, as I indicated before, I gave the same directive. I didn't tell him, this is what I want you to do on this day. This is what I want you to do on that day. I said, I just want to know who they're meeting with and what they're doing.
Did you get a report from Brad Miller as to the scope and extent of the surveillance that he conducted?
Objection. Relevance. Beyond the scope, and vague as to time.
There were questions about surveillance by the defense.
That's true. Vague as to time as sustained.
Well, the period of time that the surveillance was conducted was what, 60 days?
No, I think it was less than that. I think it was about 30 or 35 days, something like that.
And it commenced when?
Sometime after February 7th.
Sometime after February 7th?
Yeah.
Were they actually being
Yes.
surveilled while they were at Neverland?
I don't know that I don't think Brad was ever at Neverland. If I had to, if that's what you're asking me.
Well, if you've directed Brad Miller to conduct a surveillance of the Arvizos family as early as the 7th of February, then you would have been informed as to exactly when they were at Neverland. No.
Objection. Argumentative. Assumes facts.
Overruled. You may answer.
Mr. Zonen, what I directed him to do was find out who they were meeting with, what they were doing, and then give me a report back. And he would have given me a report back saying, they're either here or they're there. We either found this out, we didn't find this out. I did not ask him to tell me exactly who he was using. I didn't get into that. It didn't occur to me at that point.
Did Brad Miller tell you that the children were meeting with Michael Jackson during that period of time?
Objection. Hearsay. Relevance. Beyond the scope.
Overruled.
That was overruled.
That means I can answer?
I think it does, yes.
Thank you. I don't believe so. I didn't have the impression, at least, that when he was finding out what they were up to, that included any time that they may or may not have been at Neverland.
Did you have an opportunity to review the surveillance tapes?
Not prior to November.
You directed a surveillance be done as early as the 7th of February?
I directed that they find out who they were meeting with and what they were doing.
All right.
I know you keep saying, surveillance. I didn't tell them to go sit in a car outside. I didn't give them directives as to how to do it. All I said is, find out who they're meeting with and what they're up to. As I explained last week when you asked me this, the concern is that they were either going to go meet with a lawyer of some kind to make some accusation, or they were going to sell the story to the tabloids. The extent of what he did I learned sometime later, but did not know at the time. And what I knew at the time was that they were either here or there at particular points.
Do you know where those surveillance tapes are today?
Objection. Relevance. Beyond the scope.
Overruled.
I assume in Steve, the sheriff's possession.
Are you saying that all the surveillance tapes were kept at Brad Miller's office?
The surveillance tapes, as you call them, all I'm aware of in terms of surveillance tapes were the things that were seized during the search warrant.
You never asked Mr. Miller if, in fact, there were additional tapes other than the ones seized during the course of the search of his office?
Objection. Vague as to time. Relevance. Beyond the scope.
Overruled. You may answer.
I would have to assert the attorney-client privilege, because I think built into the question is asking me what my discussion.
All you have to say is you refuse to answer because you're claiming the privilege. That's all. Next question.
Up until the time of your client's arrest, did you ever view any surveillance tapes?
Objection. Relevance. Beyond the scope.
I'm trying to establish if the ones in evidence are accurate.
The objection is overruled. You may answer.
No, I don't believe that I did.
All right. Were you ever briefed as to the content of those surveillances?
Objection. Vague as to time. Relevance. Beyond the scope.
Sustained as to time.
Were you ever briefed before the conclusion of the month of April 2003 as to the content of the surveillance tapes?
I think I was, yes.
All right. Did they tell you that who was it who briefed you?
It would have been Brad.
Did Brad tell you that they conducted a surveillance of Janet Arvizos' parents at their home in El Monte?
I think that he did.
Did you direct that they do a surveillance of her parents?
No. As I explained before, I told him, find out who they're meeting with and what they're doing. I didn't.
Objection. Objection. He cut off the witness.
Sustained.
Could the witness please answer, Your Honor?
If you haven't completed your answer, you may do so.
Thank you. I said I didn't specify the exact locations or what they should do.
Just 1 second, Your Honor. Are you aware of any other surveillance tapes other than the ones that we seized from Brad Miller's office?
No.
Objection. Relevance. Beyond the scope.
Overruled. You may answer.
No.
Are you aware if the Brad Miller tapes seized from Brad Miller's office have been altered in any way by Brad Miller?
Objection. Relevance. Beyond the scope.
Overruled. You may answer.
No.
Or are you aware of whether or not there's additional footage to those tapes that have been excised or deleted from the tapes?
Same objection.
Overruled.
No.
Now, at some point in time you became aware of the fact that there was a tape recording of the telephone call between Janet Arvizos and Frank Cassio. Is that correct?
Objection. Vague as to time. Relevance. Beyond the scope.
Overruled. You may answer.
I can't answer that because of attorney-client privilege.
Did you ever listen to the tape recording of the conversation between Janet Arvizos and Frank Cassio?
Objection. Relevance. Vague as to time. Beyond the scope.
Vague as to time.
Did you ever listen to that conversation up until the time that your client was arrested?
No.
Did you know that it existed, that tape recording?
Up until the time of the arrest?
Yes.
No.
Did you have a conversation with Brad Miller about conducting or monitoring conversations between Janet Arvizos and any of the other employees or people who work for Michael Jackson?
No.
Objection. Relevance. Vague as to time. Beyond the scope.
Vague as to time.
That last question that I asked, if I were to say up until the time of your client's arrest, what would your answer be?
Same objection.
Counsel, I'm going to tell you again. The area that I think is relevant on some of these questions is the time period that he testified to on direct where he was doing certain things. And your questions are relevant. You know, it's not the cutoff date that's relevant. So I'm just trying to give you some guidance.
Thank you. Perhaps that question could be modified, then, through the end of April. Do you remember the question?
I do, and the answer is no.
Pursuant to the surveillance investigation that you had directed Mr. Miller to conduct, were you kept advised as to the movement of Janet Arvizos between Neverland and her home or Major Jackson's home?
Objection. Vague as to time. Relevance.
During the period of time of the surveillance, which is roughly 30 days from the 7th.
When you say kept apprised, I'm sure that I would have had conversations with Brad, and he would have told me in general terms what was happening.
Did Brad Miller then tell you the number of times that Janet Arvizos left Neverland and then returned?
You know, as I sit here, I don't remember him telling me. I know your focus on the question is Neverland and returning, and I don't think that was really the focus of what he was doing. As I indicated before.
Your Honor, I'll object as non-responsive.
Sustained.
I do not believe that he was. If he did, I wasn't paying attention to it. I was concerned with other things.
Did he tell you that Janet Arvizos left Neverland on the 12th of February at about 1 o'clock in the morning?
Objection. Vague as to time. Relevance. Beyond the scope.
At the time, concurrent with those events. In other words, within a few days of the 12th, did he tell you that?
All right, he's changed the, I'll accept that change.
Probably did.
Did he tell you within a few days of the event, in other words, contemporaneous of the event, that the family returned to Neverland within a few days thereafter?
As I sit here, I don't remember. I do have a memory of being told that she had left, but I don't know about her returning.
All right. Would you have been concerned about the prospect of the Arvizos family returning to Neverland?
Objection. Calls for speculation.
As not being in your client's best interest?
Objection. Calls for speculation.
Just a moment. I don't want you to add to your question after there's an objection. It's okay on that timing, but it causes me difficulty when you're.
I actually intended that to be one question.
All right. Why don't you just rephrase the question?
Give me a moment. All right. Did you have concerns about the Arvizos family returning to Neverland after they left on the 12th?
I had concerns about the Arvizos family.
But particularly in the context of them being in the presence of Michael Jackson?
Yes. I always had concerns about the Arvizos family from early February, meaning sometime after the 7th or the 9th, something like that.
Did your concerns include a concern that Gavin Arvizo would end up back in Michael Jackson's room?
Well, when you say back in his room, no, that wasn't my concern. My concern was that there was going to be some kind of an accusation made, that there was going to be some kind of a false story concocted. That was my concern.
Did you at any time contact Michael Jackson after the 12th?
Objection. Vague as to time.
It's in the midst of the question. I'm just putting the time parameters on it.
My apology. I withdraw the objection.
After the 12th of February, at any time after the 12th of February, within the next week or so, did you have a conversation with Michael Jackson about not allowing the Arvizos back on the property?
No, I don't think that I had a conversation about anything to do with them coming back and forth to the property. I wanted to know what they were up to. I don't think I had a conversation as to them coming onto the property.
Alright, Mr. Geragos, you knew that there was going to be an interview that would take place in the late evening hours of the 19th into the early morning hours of the 20th that was going to be part of Take 2. In other words, a filming of the Arvizo family that was designed or intended to be a part of this commercial production. Is that right?
I knew that they were filming what they called, it wasn't, as I remember it, they kept referring to it as the rebuttal.
Were you aware that there was a substantial amount of money that had been paid to Michael Jackson by Fox Studios in advance of the filming of that production, an advance towards that production?
Objection. Assumes facts not in evidence. No foundation. Beyond the scope.
Your Honor, it is in evidence, and the exhibit specifically is 898.
The objection is sustained.
Were you paid out of an account that was funded by Fox Studios?
Not that I'm aware of.
Did you know from what source came your income?
Objection. Relevance. Beyond the scope.
Sustained.
Could I be heard, Your Honor?
Yes.
Could we do it at sidebar?
All right. Discussion held off the record at sidebar.
Based on your briefing with either Brad Miller or any employee of Brad Miller, did you learn that Janet Arvizo had been entirely complimentary of the defendant during the course of the interview that was tape recorded in person at Major Jackson's home on the 16th?
Objection. Hearsay.
Overruled.
Yes.
She had nothing bad to say about Michael Jackson at all?
That was my understanding.
Based on your briefing with Brad Miller about the content of her interview with the Department of Child and Family Services, is it your understanding that Janet Arvizo had nothing bad to say about Michael Jackson in that interview as well?
Yes.
Okay. Did you understand that she was going into that interview concerned that her children would be removed from her custody?
I don't know that I knew that prior, but that would not surprise me. I mean, it's a Department of Children's Services interview. I think anybody would be concerned.
Would it be your expectation that the more complimentary she was of Michael Jackson, the greater the likelihood that they would not take her children?
Objection. Foundation. Calls for speculation. Relevance.
Overruled. You may answer.
I don't know that that was the thought process. I believe I was told that she had previously had close encounters with the DCFS and that was her concern.
Did you direct Brad Miller to work with anybody from Michael Jackson, anyone among Michael Jackson's employees in terms of conducting his investigation?
I don't know that I directed him to talk to anybody in particular. I told him to go. I told him to contact people and investigate, do what an investigator does.
Do you know who paid the balance of Janet Arvizo's rent at her Soto Street apartment?
I think at the time. Are you talking about in April of 2003, roughly that time period?
Try March.
In March. I think I knew in April that Brad had paid it.
Alright. Did Brad Miller have money to be able to pay that?
Probably not.
Alright. So do you know how he paid that?
I would have told him to get reimbursed from the accountant.
Did you advance any money?
I did not.
Did you advance any money toward emptying out the apartment?
I did not.
Did you tell Brad Miller that he should go ahead and pay off the balance of the rent on that apartment?
I don't know that I told him. I know that he told me he was going to do it. I don't know that I told him to do it. I mean, I know that he told me he was going to do it or he had done it. I just don't remember the context of the conversation.
Did you ask Brad Miller where the Arvizo family would be moving once that apartment was moved out?
He had told me that they were moving in with her boyfriend.
Did you tell Brad Miller, this is not a problem for Michael Jackson to be paying for cleaning her out of her apartment?
What do you mean? Cleaning her out of her apartment.
Moving them from the apartment and putting their things in storage. This is something that Michael Jackson ought not be involved in. Did you tell him that?
He was talking to Janet. Janet wanted that done. Janet was trying, according to him at least, to get these things done. And I told him if he was going to do that he better videotape the contents so that there later is not an accusation that something was tampered with.
Why did you tell Brad Miller that he should move Janet Arvizo out of her apartment on Soto Street?
Did I? I didn't say I told him that.
Why did you approve it? He works for you, right?
He works for me. He said that she wanted that done. He was going to assist her. He was trying to be on her good side, I guess for lack of a better term.
Did you know at the time that she was moved out of that apartment where her possessions went?
I don't think at the time, no. I've learned later on.
Alright. Now, did you instruct Brad Miller that he should place them in a locker someplace under his name?
No, I don't think that I did.
Do you know under whose name her possessions were, in fact, deposited?
I learned that later, yes, that it was under his name.
Alright. Now, did you, as soon as you learned that, did you immediately instruct him to change that?
Well, no. When I learned that was when I got those letters from Mr. Dickerman. And he and I went back and forth as to where he wanted the stuff. And I think at one point I told him that he could take over the lockers. I offered to have him switch it to whatever name he wanted, and I think we went back and forth on that.
May I approach the witness?
Yes.
Mr. Geragos, I'm going to show you exhibit number 630. I'd like you to take a moment and strum through those collection of documents in that exhibit, if you would.
I've strummed through it.
Strumming through documents is something lawyers do well, right?
I don't know if we do it well. We do it a lot.
Mr. Geragos, do you recognize those documents as being a compilation of letters sent to you by Mr. Dickerman and a few letters sent by you back to Mr. Dickerman in response?
No, I do not.
You don't recognize any of those letters at all?
I think you have probably given me the wrong exhibit. Laughter. You haven't been strumming documents enough.
It's the wrong exhibit. Laughter. Could we have 629? My fault, not his. You could have told us at the early stages of the strumming.
I couldn't figure out why you were having me look at it. You were close. It was the right lawyer. Just the wrong series of correspondence.
Maybe we ought to just start our break early, huh? Okay.